But moving on now, the High Court has barred magistrates from hearing land cases, as had been directed by retired Chief Justice Dr. Willie Mutunga. The judges ruled that was the sole mandate of the Land and Environment Court. The ruling is a major setback for resolution of land matters, as it is sure to complicate the backlog. Let me bring in now Duncan Okach, not a new face here on News Center. He is an advocate to tell us more about this. Now, Duncan, what was the initial reasoning by Dr. Willie Mutunga for him to allow the magistrates' court to hear these land cases?
Thank you, Betty. It is common knowledge that most of the matters that are actually forming the major aspects of backlogs in the judiciary are matters related to land, environment, and land use. And it is in the view of that you see judges are being appointed in numbers to try and deal with that. And I think that is what informed the Chief Justice's view of trying to empower the magistrates to be able to deal with such matters, to avoid the backlog and also to avoid a sense of despondency among people who are squabbling over ownership of land or use of land.
Was it in accordance with the law? Because, on one hand, you have, him saying that it is okay for the magistrates to hear, but now that is being done away with.
Betty, if you ask me if it was in accordance with the law by the time he was doing that in March 2016, it was in accordance with the law because we had an act of parliament, which is the Statute Miscellaneous Amendment Act 2015, which was assented to by the president. And it's an omnibus act which brought in a lot of amendments to the existing laws. Pertinent to this is the High Court Organizational Act. Secondly is the ELC Act, that is Environment and Land Court Act, and the Employment and Labor Relations Act.
Okay.
What it actually meant to do is to empower the Chief Justice in his administrative capacity to be able to empower magistrates to deal with certain matters which will cut across employment matters and will cut across land matters. However, we go back to what we call the grand norm, that is the Constitution itself. All acts should be in conformity to the grand norm, that is the Constitution. The Constitution under Article 162(2) says that creates two courts, which is the Labor which is the ELRC Act, Employment and Labor Relations Court.
Right.
And it creates another court, which we call the ELC, which is the Environment and Land Court. These two courts are given the status of the High Court. And actually, the ELC court is to deal with anything that touches on land and ownership. Employment court deals with aspects of employment. However, judges to these particular courts are sworn in a special way because we have the act that has provided over and above the constitutional provisions, has given them more qualifications or qualities, such that these judges are not just the ordinary judges that we find. In actual sense, the case in Malindi was even challenging the issue of transfer of these judges and whether a judge in ELC court can even deal with any other matter. Mutunga, in his wisdom, tried to see, actually saw that this is actually something that is boggling down the administration of justice, especially the ELC courts. And he thought that if we are to limit, we had, I think, less than 14 ELC judges countrywide.
Okay.
There are others who have just been appointed, they're here to be sworn in. So in actual sense, land matters were not actually getting any headway. And there were a lot of procrastinations. And that is why he thought magistrates could deal with it.
All right.
But,
speaking about, headway, I mean, one of the reasons, like you mentioned, of course, was the backlog of cases because they are the majority of cases we have in our courts. So is this really a solution? Is this the best way to go about it?
It is ideally and principally it will not be the best way because we know obviously that magistrates are so many in numbers you can't compare to judges.
About
and
300.
They're widespread. They're widespread. Empowering them, actually Mutunga empowered 168 magistrates in January to deal with this particular case.
What does empowering mean? Was it training?
Empowering, he actually gazetted them pursuant to now the particular powers given by these acts, which have now been impugned by this court.
But did they get some sort of, training, like you mentioned, the ELC judges magistrates have some special kind of training or abilities, like you mentioned? Were they trained to deal with such cases?
They went for training seminars just before they took over. However, these particular trainings envisaged under the Act is based on experience, based on
Okay.
exposure and such. That is
Okay.
what qualifies you to be a judge.
Okay.
And basically, they are competent to deal with these matters. Before the Constitution, these magistrates, according to the Magistrates Court Act, could actually deal with land matters up to a maximum of, I think, 500,000. So they were dealing with it. It's not something that is new. And that is what informed Mutunga's decision. However, and unfortunately, the Constitution lays supreme. And in our Constitution, we say that it is only a magistrate who becomes a magistrate pursuant to the qualifications written in Article 162 that can deal with either an employment matter or a matter relating to land, and no other. And that relates to judges.
Judges, yes.
Magistrates cannot, unless we amend the Constitution. And that is what the court in Malindi has said. Despite the noble reasoning and the noble perspective by the former Chief Justice, the problem is the law that we have, and we are guided by it. And that's why sometimes you hear people complaining about the law and giving it different terms. But that is the law, and we are guided by it.
So what kind of impact, do we expect? Because, this magistrates hearing these cases was to ensure that we don't have this backlog of cases. But now that that will not be happening, what impact are we going to see in the coming months, years?
Betty, the first thing is that pursuant to the directives given by the Chief Justice early in the year, magistrates, the 168 magistrates took up cases. They've handled cases. Most of them have even been determined. Some are ongoing. Some have interim interlocutory orders. And the problem with this particular ruling is that it actually reverses everything that has been done by these magistrates.
Everything. So the cases are now back to scratch.
Null and void, or even the determined ones, just by virtue of this particular decision, because they didn't have the power in the first place to even entertain or hear these particular cases. And the reasoning is that we know the law does not work retrospectively. However, the Constitution was there in August 2010. And from there, what this court has said is that anything done in contravention to this Constitution from then is null and void. Therefore, we will have a lot of matters being revived. We'll have a lot of parties going back, whether you lost, whether you won, going back to court. And now they have to file these particular cases in the High Court. And not only the High Court, but now the ELC courts. Because even transferring a magistrate across is already outlawed.
But isn't this crazy, Duncan? I mean, if all the cases we're talking about since, did you say March?
Yes.
To now, I mean, I'm sure those are very many cases which have been determined, like you mentioned, others ongoing. So why did it take so long for this decision to be gotten to? I mean, really, it's been it's been like about 8 months.
Yes.
And we have Kenyans who are really struggling with these, cases. And especially land is such a emotive issue, even to families. You can imagine the kind of impact it's going to have.
It's such an emotive issue because maybe pursuant to a judgment, someone constructed a flat, someone constructed a house for the family, someone has even sold the parcel, and maybe there are subsequent sales. So there are issues that obviously will come up. But you see, the timing of this was initiated by the petition by the Malindi Law Society branch that actually crafted the petition number 3 of 2016 and took it to court. If anyone else would have taken such a matter to court earlier, the better, to challenge the Chief Justice's directives. Unfortunately, we are stuck here because the court had to declare what the Constitution says, and it had no alternative. The ramifications are there. We'll have to deal with it. It will be very painful, I tell you. But you see, this is the time, because if we didn't do it now, someone else will say we may have done it next year or the year after. This is the earliest time that we would have done it, and we'll deal with the consequences now.
I mean, that's a bit unfair to to people who've gone through the process. But let's talk about this now. These special courts and these judges. How spread are they in the country? Are they only in Nairobi? Will they be? I mean, where are they?
The former Chief Justice established high courts in almost all counties in the country, and basically, when you establish a high court, you have now judges sitting there. However, and pursuant to now the provisions I've told in the Constitution, it's not any judge who can sit in as on an employment matter, neither can any judge sit in on a matter touching on land. So you have special judges. With these special judges, I told you we have very few, we had very few of them. And even with the ones that we anticipate will be sworn in any time now, they cannot even match to have one per each county.
Okay.
Therefore, we have what we call the rotational kind of judgeship. So a judge may sit in Nairobi, may sit in Nakuru, may then sit in Kericho, and then come back. It doesn't help a lot because you find that cases still don't move because you have to wait for this judge. When you have something that is very urgent, you have to pursue the judge maybe in Nairobi. It is what we are trying to cure, and it is not the ideal situation. And I think we are trying gradually to match up to what the Constitution wants. And now, especially coming with the effects of this particular judgment, it means that the powers that be should actually ensure that they now ensure that we have more and more judges. At least we have in each county one judge. In Nairobi, we are lucky. Maybe we have 3 ELC judges. But I can tell you there are counties that don't have even one.
Wow. Thank you so much, Duncan Okach, for your insights. I think we're more troubled than we were before you came. Thank you so much for your insights. He is an advocate. All right.